What's the urgency of this?
Orders next week any day.
17th.
I'd like to mention that WBC item for this thing.
20. 20.
Hey, please, I'm going to request for making a 28%.
20 seconds.
All right.
Next is motion. I'd like to mention for listing motion to make this motion. Thank you.
24th.
I'm paying for this admission for admission.
24th.
I think one of the motion.
That is the loss. That is regarding appointment of compassionate ground loss. Earlier in this case, the rejected loss. The opposite honorable court is honorable court interfered with the matter losses, remanding back the matter. Now this time also they rejected my claim, saying that vacancy is not there. My father lordship expired in the year 2011 lordship. Throughout these years, they were sitting over the matter. In 2021 lordship, they rejected my claim saying that that balance period of 3 years of my deceased father is not there, so I'm not eligible to get the appointment on compassionate ground. That was interfered with this honorable court lordship, saying that this OM is not applicable on me since my father expired prior to this OM lordship. This time again they rejected my claim lordship. Now this is the new ground saying that vacancy is not there. It is like that the lordship they don't want to give several times they are rejecting my case lordship.
Additional file, additional available. Is that additional file, additional available?
Additional affidavit.
Yes, additional.
Yes.
From where it is apparent that there was no vacancy from 2011 to 2013.
Actually lordship on past
It is, so no, it's the page 60. Cadre strength is 25 in other department. With that, 2% already appointed.
that is in the year 2013 lordship.
Yes, my lord. In a competition regard within 2 years, it has to be considered. And after that, if it is not considered, the expense is paid. So, because her father died in 2011, and it was considered within 2 years. And at that time, education as well as other department, there was no vacancy. But thus it was rejected.
On the ground of no vacancy, can you just reject it like that? When was the last rejection?
It was in 2022.
Page number 51. 7/5/2020.
22, page 54.
By then, the OM of 2015 is applicable. When you apply close 10, 15.
Yes, 15. And the provision is also there in ADLR department.
Yes, then
My prayer is only placing my case before the DLC lordship. Question. Nothing. I'm not praying for the appointment. They are not placing my case in next days.
yes.
And there is a
There
provision
is
of
a lot of
2015.
direction to place some matter fresh and PLC may consider as per law.
Yes, Lord.
In accordance with law.
But MSS Kono Learner Council of Petition. Also heard elementary workers. Three Talukta Learner Standing Council Elementary correspondence. 1, 2, 3, and 4, and Mr.
G. Bhulapur, 5.
Bugale for rest 1 number 5. Governor. Pala. The father of the petitioner, let Abdul Jalil Chowdhury, while serving as a grade 4 employee of Nis Bernardpur ME Madrasa, died in harness on 7/10/2009. Stop. Petitioner accordingly met his application for appointment on completion of grounds on
Application I don't have, but the rejection. first
within
rejection,
the
pay number 23.
specified period of time. Stop. Thereafter, the concerned DLC, where that first DLC,
First DLC Lordship 23, page number 23. Lordship. First rejection Lordship.
concerned DLC held its meeting on 5/10/2021 and rejected the case of the petitioner on the ground that the remaining balance of the deceased employee was 2 months, 26 days, and therefore in accordance with the OM dated 1st June 2015, this case could not be considered.
That was interpreted Lordship, page number 47.
Being aggrieved, petitioner opposed this court by way of filing WBC number 7122 of 2021, which was disposed of by order dated 7/1/2022, 7/1/2022, interfering with the observations of the DLC and with the further direction, interfering with the resolution of the DLC, rejecting the application of the petitioner on the ground that the disease had a balanced period of service, which was less than 3 years, and the matter was remanded back to the DLC concerned for fresh consideration as per law. The DLC again consider the case of the petitioner in its meeting held on 7/5/2022.
Last page by rejection Lordship.
And
24.
his case was again rejected due to non-availability of vacancies within 5% of the total cadre strength in education department or other department across the district. It was further observed that her case, his or her,
Lordship is.
his case would not be recommended by the DLC and kept pending for placing before the next DLC. Grievance of the petitioner is that despite the observation made in the DLC minutes dated 7/5/2022, his case is yet to be placed before the DLC. After hearing on the concept of the parties, common district petition is disposed of, directing the Deputy Commissioner, Hailakandi, to place the case of petitioner,
Department will place before the
Department will place.
directing the department to place the case of the petitioner before the next immediate sitting of the concerned DLC, which in turn shall consider the case of petitioner in accordance with law. With the above affirmations and directions to the petition.
Move.
My lord, today, my lord, for consideration of the order, my lord. My lord, honorable court order, my lord, is today, my lord. Honorable court will go to the order, my lord, case when order, my lord, dated 27/1/2023, my lord. My lord. May I read if one of the permit me, my lord. My lord, one thing is that my lord, petitioner was a claim for employee, my lord. That was as a night supervisor, was appointed on 8/12/1999, my lord. And college, there the college was before provincialization of the college. There the college was provincialized, but his school was not provincialized. And regularly, so many communities on our court permit me. This last on our court order, my lord, your lordship. Go to your on our permit, I will read it, my lord.
Yes.
May I read, my lord? Petitioner stated that by order dated 27/1/2023, petitioner stated that he is serving as grade 4 employee night supervisor in the Navisa College, North Lakhimpur against a non-section post from 9/12/1999 since the time the said college was in grants in 8 states. It is also stated by the petitioner that though pursuant to the provisions of Assam College Employees Provincial Act 2005, say Navisa College was brought under provincialization with effect from 1/12/2005, but his service was left out of the provincialization as he was appointed again non-section post. The authority of Navisa College on 24/11/2022 issued an advertise inviting application for fill up different posts together with 3 posts of grade 4 laboratory, where library, where with 1 post grade 4 reserved for OBC category, 1 post grade 4 laboratory where for unserved category, and 1 post grade 4 library reserved for scheduled caste. As the petitioner is already overrated for any such public post and have also crossed the upper age limit in terms of the said advertisement dated 24/11/2022, he did not apply for the post and grade 4 as advertised by the Navisa College on 24/11/2022. However, the petitioner has played for regulation of his service as a grade 4 employee and said Navisa College, since he is serving in it from 8/12/1999 for last more than 23 years and has about only 4 years of service left in his career. We are going to return on only 4 years left. Filing an additional affidavit, it is also placed for the court that petitioner on 21/1/2023 submitted a representation before the Director of Higher Education Assam, praying for regulation of his service as grade 4 employee, and said Navisa College and further prayed not to fill up the post of grade 4 in Navisa College, district locking in terms of the said advertisement dated so and so noted. That is also pending till today. Petitioner stated that pursuant to the letter of Director of Higher Education Assam so and so norm dated 7/5/2022, the principal of the said Navisa College submitted detailed report before the said director containing the name of the petitioner as a grade 4 employee serving the said college in effect from 8/12/1999, along with 2 others, a library assistant and another grade 4 employee, and the said college, who are the junior to him in service, indicating their date of joining the said college as 23/2002 and 23/4/2002 respectively, where all 3, including the petitioner, joined the said college much prior to 1/12/2005, and that on which college was brought under 2005 Provincialization Act. Accordingly, petitioner, the state government, the Higher Education Department, have a frame a policy regulation of service of such non-teaching grade 3 and grade 4 employee of 189 number of provincialized colleges of state serving without valid sanction
Yes.
to prior 1 year. My care is that my at least 1 post will be taken.
Where? That's a different thing. You are, you are supposed to appraise this court on 2 issues. One is the letter dated 1/4/2022. And the other is whether the government has framed a policy for regularization of 191 colleges, persons in 189 provincialized colleges in the state.
But, I think is something from this, but one thing can be done. Also. I represent but all things satisfy the director also. That can be done.
But till the director considers the representation and disposes of, one post should be kept vacant. Post held by the petitioner. What do you think?
That there is also there the director, ma'am. I tell you
Then I would, and I would take this some regarding.
You don't have a copy of this order?
Cannot be looked at that.
Hmm?
The cannot be the procedure
No, you're supposed to apprise this court on two issues.
No, so I will tell you.
Whether there's a policy of regularization framed by the government for regularization of grade 4 employees.
Sometimes.
189 provincialized colleges in the state. Yeah.
There is no provisions and no constitution of the government regarding regulation of the grade 3 and grade 4 employments. Only in respect of assistant professor was engaged.
Without submitting an instruction, today is fixed for instruction. Without instruction, how can it? Last provision was directed by law. Without my law instruction, cannot matter.
I have the instruction, telephone instruction. I have a telephone, so I submitted before the lordship. There is no any policy decision from the government of Assam lordship regarding regulation and adjustment of the lordship get for employees. In respect of non-sanctioned officers who are engaged lordship, 5 to 17/7/2004, there is a policy decision of the government lordship. They are that policy decision are endorsed and by the full bench of the Honorable Court lordship. As per full bench direction, we have prepared 356 odd number of officers lordship. They are regularized as the policy decision. After coming into effect over 2005 Act and 2010 rules, there is no provision for adjustment of a person's lordship who are working against non-sanctioned posts without the permission and authority of the government of Assam. They are the internal enhancement of the college authority. We are not bound by them lordship. We have to follow the lordship equipment rules.
Then you file your affidavit.
It's a direct recruitment post lordship. It should be for other section rule 5.
Till then, don't fill up his post.
But
And Bora, then you counsel for the petitioner. Issue notice. Mr. Who appears? Boyan or Gogol? As Boyan, then standing counsel, secondary education. Appears for respondents. 1, 2. 1 and 2.
1 and 2.
And as a Borough and government advocate for this 5. Petitioner to take steps for service of notice on respondents 3, 4, and 6 by registered post AD within 1 week. List the matter of the 4 weeks. Till the next suitable date, it is directed that the post held by the petitioner shall not be filled up.
now we start for this.
Post
Now,
held
sir,
by the petitioner at now Boicha College, North
Pardon?
Lakhimpur,
Parcel to advertise the latest
shall not be filled up.
money.
Shall not be filled up.
Parcel to advertisement dated.
I'm not saying anything.
Mark.
19 of supplementary list.
Majumdar, you appearing?
They are implementing their own orders. Therefore, I don't think it should be challenging that.
person order from this honorable court on 24/6/2022 not to implement the particular policy. That might be the-
That was regard to two districts,
Madam,
two
it
districts.
was not kept confined to those two districts.
Let us see.
So if you like the page
Affected persons who have already got the order.
page
And also
68, madam. Para 30. Page 68, para 30. Even making such provisions in the Assam Secondary Education Provincialized School Service Rule 2018 in respect of promotional agreements of class 4 employees of provincialized secondary schools of the state. In the class 3 post of junior assistant in such schools, as directed by the Honorable Division Bench on 11/9/2019 with the common judgment and order passed in WPC number 997/16 and other connected cases noted above. The include of this memorandum number AC 631 of the 2019 of the 112 dated 28/9/2021 of the state government in the secondary education shall remain suspended and or shall not be given effect. With the above observation and direction.
Where is this OM? OM.
This OM has not been annexed to the resolution. Page 65. Page 65 is put in the judgment of this document. Providing 5% benefit of promotion of grade 1 employees to grade 3 junior assistant of the total post of junior assistant of a district under permission of Assam Secondary Education Rules 2018. Subject to amendment of Rule 5 of the Assam Secondary Education School Service Rule 2018. The government, after due consideration of the legal position given by the Senior Standing Council Education Department, Judicial Department, and in compliance with the Honorable Government Regulation Common Order taken 11/9/19, passing WPC number solution linked with WPC has decided that 5% of the total post of grade 3 junior assistant under a district shall be filled up by promotion from the qualified candidates among the grade 4 staff of the schools under the concerned district with minimum 5 years of experience in provincialized high school, high madrasa, higher secondary, high school, multiple schools, and the income should be graduate. And there shall be a district level seniority in gradation distance selection shall be done by the district level promotion committee. The district level promotion committee shall be headed by the deputy commissioner of the district as chairman, inspector of schools as members of the district as principal. Members shall be nominated by the commissioner of the district. The rule shall come into force with immediate effect. Now, what had happened is that 5%, so and so is decided that total 5% of the post of grade 3 under district shall be filled up by promotion of the qualified candidates. Rules provided that 5% will be filled up by direct people. This OM had converted into
Promotion.
promotion. So this was not approved efficiently by this honorable court, it approved and it was stayed. Now, before this order to be given the notice of the director of this education, since some process was already going, selections to some extent certificate users had come. That was approved under some time on 2012-2020. Other districts were there, not in the other districts, we are concerned with the government district or district to government. So now 2012-2020. So now for 2012-2022, the approval. The stay being on 24/6/2022. Our proceeding as per this way was felt by the government to be could have been taken to the effect of content. We are not obeying the laws of the law, we are acting on the way even after the state. So in that view, my lord, or Kamrup Metro District was given after the orders of this honorable court, that has been
That has been.
that approval has been cancelled because it was approved after the orders of government. Approvals given prior to the orders of the honorable court. The argument that I have in the submission that I have because prior so you can go. That we can apprise it. But here we have issued the approval, though only after the orders of government, and therefore this was cancelled. If the postponement honorable court then proceeded and this was no. If that is clarified, the department will not allow we have already approved. Nothing against it. But it is on the subsistence of a suspension order of a particular order, could be have approved. That
We'll,
case will
we'll
be a
consider the
separate-
matter, we'll consider the matter. We'll consider that aspect. But till then, let the petitioner continue.
The other way around would be, the posts that are now being filled, we must be filled as a other mode of appointment.
That's why,
But madam,
let the petitioner continue.
if they are allowed to continue this approval method, the approval will be against the orders of Mr. Mehta. That is considered as. It's not difficult, madam. We are not against them, we are not here to stop us, we are not a legal person working the case. That is never the intent of the, I have had a discussion. The only thing is, we passed an order unknowingly. Without knowing the orders of the Honorable Court, the moment it is called for notice, our first duty is to comply with the orders of the Honorable Court. So we cancel that. Approval.
There is no problem about that. But that is not, that decision relates to some other district where we are not part. And it is not a judgment in rem that way. Because persons affected were never notified. Therefore, it will be confined to that case. And this order by which we are there and this memorandum at page 65 opens by saying that it will be subject to our amending the rules. Therefore, they are taking their time to amend the rules, but they have taken the decision as directed by the division and judgment that consider whether you give by way of promotion 5%, or whatever percentage is like. Therefore, they have taken that call. They have reduced it to office memorandum, and they have specifically said it is subject to amendment of 5.2. So they are aware, and this pursuant to the division that they have done, only this has come, and on the basis of the opinion given by my learned friend. Legal
I am
opinion.
not the senior.
You are not.
I am not the senior.
Oh. Anyway, they have taken opinion. You have actually city position. That is one part. But if you cancel, I am not party to that. You have given me an appointment as per your own policy.
How many petitioners are here?
Only 8 or 9. And in all other districts, that benefit has been given. Only for us, this is Kamrut now. And Sibsagar.
Yes, it comes from this honorable board that then order will confined to those districts where the petition has.
That will-
No problem.
That will consider later on. You file your affidavit, we'll consider head Mr. B.K. Goswami, Leonard, Senior Counsel, assisted by B.B. Bora, Legal Counsel for Petitioner. Issue notice. Mazumdar, you appear?
And
R. Mazumdar, Leonard, Standing Counsel,
second,
Secretary
Department of School Education.
appears for
Department of School Education.
the Department of School Education. Then Finance, Finance will appear. B. Gogoi, Leonard, Standing Counsel, Finance, appears for response number 4. Legislative Department. Bukalia and Government Advocate correspondence. 5 friends. 7. Treasury. Gogoi for respondent. 4 and 8. Notice on respondents are complete. Respondents are allowed to file. Extra copies. Furnish extra copies, Mr. Bora. Till the next reasonable date. Petitioners shall be allowed to continue in their respective posts. So file your affidavit and I will say.
The order was the.
Yes, yes.
Yes.
The great shippers.
Free of paying this admission.
What is this case about?
matter came out on 8/3/2022. Government released the judgment of agreement submitted that covers this matter. Madam Lordship may kindly have a look at, and they have given me the judgment. And that they have to give time to my lord check whether the issues are the same and whether it is actually covered. And thereafter, my lord, to show that there are some distinctions between division bench judgment with regard to the outcome of that case and my lord, this case. I briefly, my lord, state my lord, it will not take more than 3 minutes for an objection of this case. We have, my lord, around 75 petitioners by this case. Most of them have, my lord, 55% and above in their master degree. And they were appointed in various, my lord, colleges in between, my lord, 1998 to 2003 February. All of them. My lord, the series of circulars and guidelines I will not refer came from with regard to passing out of net slate by the UGC. And again, about my lord, appointees in mental class who completed, who were appointed prior to a deadline on so and so forth. My lord, there was an exemption given initially by the UGC that those who had PhD, there may not be next step. That exemption was given. Once that exemption was given, and then again that was withdrawn. Things like that. So by this petitioners are concerned, my lord, there was a minutes of the page 68. Page 68. Minister Higher Education Director, my lord, Secretary Education, and all these people were present. May come to the last sentence of this page 68. After fair discussion, it is agreed unanimously to implement the pension scheme as per the formula. That is different. Then 69, this paragraph is important. The meeting further agreed upon to withdraw the condition of next step for college teachers appointed up to 12/1/2000 and allow them to enjoy all benefits, namely 13/1/2000 to 22/2003. So we fall here. All of us were appointed prior to 22/2003 are immediately exempted from next step up to the extent of giving seniority pay scale. Then, my lord, that was not implemented. We approached this court, and this court disposed it of with a direction which your lordship will find at page 135. Yes, my lord. Page 135, last paragraph. This court is not going into the merit of the case. Didn't go on. In view of the fact that the representation of the petitioners, we were the petitioners, they were most of us. Dated 25/11/13 has not been considered and disposed of by authorities till date. Though the Director Higher Education by a letter dated 14/11/2014 sent a proposal to the Commissioner and Secretary Higher Education for provincialization of services of teachers without mid-state PhD or newly provincialized colleges for absorbing faculty members. Accordingly, I directed Commissioner Secretary Assam to consider representation that is so and so in the light of the letter dated issued by the Director Higher Education. And gave 3 months time to do it, my lord. And when nothing was done, we again, my lord, came to this court, and lordship will find that order at page 137. In the second time, we came, most of us. And third paragraph on page 137. Today, during the course of hearing, so and so Learned Standing Council Higher Education placed a copy of a speaking order dated 65/15 issued by Commissioner Secretary, bearing memo disposing of the representation of the petitioner in terms of the order dated 2/4/15 passed the WPC numbers and serving a copy. After going through the same, that favored us After doing through the ask, they say, now the prayer of the council, the petitioners are allowed to withdraw the petition with liberty to file afresh if so advised. Now, ultimately, there are also, we are not favored, not favorable orders were given, although a few of similar circumstances, persons like I also had, I given it. So thereafter, my lord, thereafter, my lord, we file this case. Thereafter, we file this case. Lordship may kindly see, here we challenge as per the liberty given by earlier. So discriminations were writ large, my lord, in provincializing services. That is our case. Lordship may kindly see page 73 onwards. Here is almost 105. Page 105. Page first, my lord. Page 73 onward, we annex, my lord, subject orders by the government. Similarly, circumstances, my lord, district staffs and non-district staffs were, my lord, regularized. By my lord, district orders, issued series of orders, issued from time to time. These are the orders. All these orders were, my lord, passed in from 1999, next few years. Then annexure 5, you will see the particulars are
Page,
page 105. Here, the date of appointment here is also date of joining, date of joining.
Annexure 10.
Here, the date of joining column. And then, here, my lord, see, also will see, there were appointees. The entire chart is not of all these petitioners. There are others also, but so far as the petitioners, say for example, serial number 8 and serial number 4, appointed in 2001, 99, next page, another petitioner, the first petitioner, 2001, next page. Then in the next page also, some of these petitioners, my lord, in this petition, it appears that they were appointed in 99, 2003, and also in the next page, all were in 2003. Then in the next page, 99, 2000, 2001, 2003. Meaning thereby that all these petitioners were appointed from 98 to 2003. There is no admitted commission. My lord, record. And indeed, now, my lord, the judgment I referred to, your lordship will find the division that judgment has been handed over by me, by the government. That's two places I will, my lord. So, possibly straight away come. Other than two places, two major distinctions. Paragraph 4 of the judgment. Paragraph 4. Paragraph 4 of in that case, my lord, the petitioners are in venture in Assam with expectation that their services will be taken over by the government under Assam Cancer Education Institution provincialization of service in 2011. This is now, this stems repeat, this act is no more. They took admission for pursuing entry degree in distance mode from so and so. Then paragraph 5, roundabout middle. So council for contested seats and candidates were exempted. The next qualification each undergraduate level student with effect from 2006, under 2006 regulation, withdrawal exemption from the group under the 2009 regulation brought into force on 11/7/9 should not be retrospectively enforced. Now, here what I am saying that this at that time it was my lord in 2011. And so far as petitioners are concerned, then consider timely now. Paragraph 10. Paragraph 10. In the present case, exemption from net slip requirement to undertake undergraduate level teaching was granted to those MPhil degree under 2006, but the exemption was omitted under 2009. And hence, net slip was prescribed to be essentially eligible criteria for recruitment of teachers in EDC affiliated institutions. Therefore, those with MPhil who were being considered for appointment 2006 regulations would have been considered for appointment without net slip with qualification only for a limited time from, this is important, 14/6/2006 and 11/7/2009. We were appointed much prior to that, as I said, between 98 and 2003. However, post 11/7/2009, none are entitled to be so appointed as not to minimum qualification. This is, I am saying, we are appointees of 2003, and in that case, which has been, which they say that this case is covered, those petitioners were, my lord, appointed after 2006 and between 2006 and 9. Then, my lord, come to one more development. During the expectancy of this case, in fact, some of these petitioners obtained net slip. And around the result of them, we do. Their names as petitioners there. It's like and once we come to the date of judgment of this case, in this case. Justice Roy and Justice Saido. Date of order here worship we find 7/2017. But this date was before coming into force of the 2017 Act. In my case, during the tendency of my case, this case, one of the 2017 Act came into being. 2017 came into being, and therefore,
Which act? 2017, which act?
2017,
Because it's Assam Education Development of Services Research and Reorganization of Education.
so we may,
It is also 1990.
so I prefer my lord. Can you see my lord, when it came into force? Page 101. Published in the Assam Gazette, notification. Page 101 below. Published in the Assam Gazette, extraordinary dated 6 June 2007. Not on the date of publication in the official Gazette, 2017 came into force. That is, my lord, after the judgment. Yeah. After the judgment. So, meanwhile, what happened? Some petitioners they withdrew, and some other of these existing petitioners have been appointed as tutors. About appointed, I am telling you who have appointed, these are the men notice. Appointed as tutor in 2021 during tendency of this case under 2017. Petitioner number 25, 27, 29, 33, 42, around 24 of these petitioners have been appointed. Absolutely similarly circumstances. I can show one sheet. There are a series of orders like the practice matter and it out. That's Mark 1, person. He is my lord. It is not number is given. My decision. That's the number. So there are actually why am I not there in the provision of law? I will not be asking for these things. Provisions of law, my lord, section 6 will be. Okay, 115. Educational and professional qualification of teachers. Services of teachers in the entire education institution from primary up to degree level shall be considered for professionalism in the post of teachers or relevant teaching faculty in appropriate nomenclature as the case may be. Subject to fulfillment of eligibility criteria and meeting the next is procedure scheme A, B, C, D, D. University grant function. Regulations or minimum qualification for appointment of teachers and other academic staff in universities and colleges. So it's a frame they are under education. This is applicable. Now, 2 is important to us. If at all, the co-petitioners, some of these petitioners have, meanwhile, during the pendency, I have given one example. There are 24 of us. For them, actually, this living has been given, though not as lecturer, as people. These are 2, suppose, subsection 2. With services of teaching employee in a venture education institute shall be considered for professionalization as a teacher only if they have been requisite academic and professional qualifications prescribed under relevant acts. UGC and others. Requisite qualification means master degree with next level or PhD, which you do not have. Let me be very frank, which you don't have. Then please go ahead with the sentence. Prescribed under the relevant act rules, as mentioned in subcode 1, I have to say university of this section, which are applicable for the time being in force. Otherwise, this is important. This one. Otherwise, if they are not so qualified, but are working for long years, otherwise their services shall be provincial as tutor, not lecturer, as tutor. Yes, I did. So, in that light, around about 25 petitioners of this, around 70, some a dozen of them who joined, because they are during the pendency, they got next step, and they got appointment as minor lecturer. And some of the petitioners have already been under this provision that I am showing, that they have been appointed as tutors. Some, yet some other of these same very petitioners, very certain have not been appointed as tutors. Now, I will not even say, your lordship, to give a direction to the government to appoint them as tutors. I would say, lordship will make an observation that some of these petitioners themselves have meanwhile been appointed in 2017 and 2017 rules. There is a provision for appointing persons without having as tutors. And in this case, my lord, we are the petitioners and serving from 1998 and 2003. Most of them have crossed the age limit of 48, 50 already. There is no chance for us. Giving this petition. So, number 25, 27. In that fact, giving that forward observation, government, apparently, political authority of the government to consider the rest of the petitioners appointed. That much I am not asking for. I am not asking that you are also to give it appointed.
Original paragraph is forward also. Already it is nice saying that we will not consider the petition on the basis of the prayer made in the original petition. Under even 2011 Act of established by High Court, the petition was filed during the lawsuit platform 2011 Act. Now 2017 Act came into force, and my civil science rightly point out that regarding those educational qualification part of the kindly for a moment again also 116 page number
Of the act,
of the Act. 116 D laws.
D.
The University Grants Commission Act 1956 and University Grants Commission regulations on minimum qualification for employment of research and other academic staff of universities and colleges and measures for the maintenance of standards in higher education 2010 came thereunder as the case may be. 2010 regulation stipulates that the required qualification is minimum 55% of marks along with net SLAB or PhD. PhD as per 2009 PhD regulation. After the 2016 PhD regulation. Admittedly, most of the petitioners have not yet required qualification, so they have deferred the petition in 2011 Act for exemption of net SLAB. This was already decided by our High Court Division Bench on the basis of the judgment passed by the Apex Court in Chila's case. Honorable Court observatory that there cannot be any exemption of it. The persons who should be appointed as a lecturer who have to fulfill the required qualification prescribed by the agency lawsuit, that is the net SLAB and lawsuit PhD along with 55% of marks. Now lawsuit, kindly come to lawsuit subsection 2 lawsuit. Subsection 2, we said there is a provisions lawsuit. The persons who are lawsuit serving as a lecturer in the Bhansar state, but the persons who don't have any requisite qualification prescribed by the agency lawsuit, they are appointed as a tutor lawsuit subject to fulfillment of other conditions. Subject to fulfilling other conditions lawsuit, it also includes the enrollment lawsuit and other things also. If they fulfill that particular category lawsuit, then they are appointed as a tutor lawsuit.
Who is the subject to fulfillment of other conditions?
You have to go to the, you have to read the act as a whole. Because lawsuit X provides lawsuit under how many students what this will be given lawsuit, and after 150, 1 will be given. If they include provision in that act, the act itself.
I should dispute that because there are some petitioners
I have also not disputed that fact. The some petitioner already.
Section 7, Section 7.
Section 7. Already appointed as a tutor lawsuit. Some petitioners have already appointed as a tutor lawsuit. And because they have lawsuit, they have followed. They are not facing the pair regarding exemption of next. So they are within term of subsection 2 lawsuit.
Subsection 2 read with Section 7. Correct. Let us see Section 7.
Education and professional qualification of tutor. The tutor must acquire a prescribed educational and professional qualification within the period of 5 years time. They have given a gestation period of 5 years time to meet that particular period of it. They have to obtain the required qualification. Here they have the 55% of marks, which is no dispute lawsuit. They have to acquire net, SLAB or PhD lawsuit within the period of 5 years. It is the basic requirement lawsuit. On the date of publication of the order for registered service of the research or a tutor under concerned Bhansar education institution in the official gazette, after acquirement of the required qualification, they shall be updated to the post of research in appropriate gazette. If such tutor fails to acquire such prescribed qualification within the period of 5 years from the date of publication of the order of organization of the official gazette, that cases shall not be considered for application to the post of research after the lapse of a period of 5 years from the date of publication of the registration order in the official gazette, and they shall continue to function as a tutor as per same terms and conditions which are applicable to them before registration of the concerned Bhansar education.
I agree with that. But you see, the tutor must acquire the prescribed qualification. After being appointed as a tutor, he gets 5 years. Here, 25 of us were appointed in 2021. By 2026, and of 2026, they will not have to acquire. If they pay to acquire, they are out. Observe that info should be. Suppose 25 of us would be. And we appointed a tutor. They also equally good. And they will get 5 years.
Again, also, Madam, I come to page 110 also. 110. But also, we have to read act as a whole also. The act is Indian provisions regarding also what, how many research we appointed on the basis of the student which is in the institution also. For organization of service of additional research, that's why or tutor as a case may be. For a particular subject, including the core subject in addition to the post.
You are reading? Reading?
page 110 lotse.
Hmm.
110 lotse.
Hmm.
Reported lotse 7. 7 lotse. For the provincialization of certificates of one teacher or tutor as the case may be, in its subject, including the core subject in case of the Bensar High School or Bensar High Madrasa or Bensar Higher Secondary School or Bensar Secondary School, at least 10 students must have appeared in the last final examination in that particular subject from the instrument. Further, for provincialization of certificate maximum limit of 3 teachers or tutors in a particular subject, as the case may be. In case of the Bensar Degree College, it is in respect of the petitioner's lordship, Bensar Degree College, at least 15 students in that particular subject must have appeared in the last final examination from the college. Can lordship 9. For provincialization of certificates of additional teachers or tutors as the case may be, for a particular subject, including the core subject in addition to the mentioned in section 317, in any Bensar High School or Bensar High Madrasa or Bensar High Secondary School or Bensar Senior Secondary School, the minimum students appearing in the last final examination of the highest class of the said school for that particular subject must exceed 80 for one additional course and 150 for the second additional course. Further, for provincial service additional teacher or tutor, in the case may be for a particular subject, in addition to the post mentioned in section 317 in the Bensar Degree College, which is applicable to the petitioner's lordship, the minimum students appearing in the last final examination of the first class for that particular subject must be more than 150 or 50 or one additional course. So, also the petitioners have to fulfill all the required criteria stipulated by this act lordship. The include provision lordship, they have to fulfill the other criteria also for consideration as a tutor lordship. So, lordship in the plan also they have not done because they have already they are original, they have made the petition, they have already not placed.
This thing, Maru, they have to check whether what classes I am taking, there are 15 students or not. Because already.
Otherwise, lordship, the original, on the basis of the original plan, the petition is not maintained. Because we are seeking the tutor lordship on the basis of the 2017 act lordship. So lordship may try to opposite examine that on the basis of the provisions contained in 2017.
And 24 of us already appointed as teachers. Maybe one or two not qualified, okay, qualified. 20%. That's all.
You are appointed from
1990 to 2001 February.
19? 19?
In between year 1998 and prior to February 2001.
2001.
And the other this kind of, they were all post 2006.
Is it 2001 or 2003? 1 or 2003 February?
From 19 to 2003.
That's what I'm. But Mr. A.C. Bogo, then senior counsel assisted by Mr. M. Smith, then counsel for petitioner. Also heard Mr. K. Gogoi, then standing counsel, higher education. For the respondents. Chief Secretary, who's appearing? Mr. Bukale, then Government Advocate appears for the respond number 1. Mr. K. Gogoi, then the standing counsel, higher education appears for respondents 2 and 3. Mr. B. Gogoi, 2, 3, and 5. And Mr. B. Gogoi, then standing counsel, finance for respond number 4. Stop. Follow. The petitioners were initially appointed in various venture colleges of Assam as lecturers within the now redesignated as assistant professors pursuant to a selection process against vacant posts in between the year 1 to 2000 to 14 to 2003, correct? 14 to 2003. Stop. All the petitioners are possessing the requisite, are possessing MA, MSc, MCom degrees with 55% and above marks. And above 55 and above 55 and above marks. Stop. It is, however, not disputed that none of the petitioners have the NET/SLET or PhD degrees. Stop. By the present writ petition, petitioners are praying for provincialization of the service as tutors in terms of the Assam education within bracket provincialization of services of teachers and reorganization of educational institutions, close bracket, Act of 2017, within bracket, Act of 2017, short. Para. Learned Senior Counsel for Petitioner submits. How many petitioners who have opted out?
I am fine. But doing themselves.
How many have
81.
out of the
Because they obtained.
out of the total 76 petitioners, 18 petitioners have opted out
Because they obtained.
in as much as during the pendency of the suit petition, they obtained the net/SLET or PhD degrees
Appointed as lecturer.
and were appointed as lecturers under the Act of 2017. Para. Another Senior Counsel, while foregoing all the prayers made in the present petition, limits his submission only for considering the case of the present petitioners for provincialization as tutors in terms of section in terms of section 6 within bracket 2 of the Act of 2017, which provides that if the teaching employees in a venture educational institution does not have the requisite qualification as prescribed under section 6, their services shall be provincialized as tutors, subject to fulfillment of other eligibility criteria prescribed under the Act of 2000.
Some number already appointed as, some of us already appointed as tutors.
Even the present petitioner, that's tutors. So, he also submits as some of the petitioners. No, I don't think you have been appointed.
Appointed as tutors. I am giving one example.
So these are the one who opted out, isn't it?
No, tutor.
In the meantime, it is also submitted that some of the petitioners were also, that the services of some of the petitioners have also been provincialized as tutors. Stop. He therefore prays for a similar treatment to the other petitioners for being provincialized as tutors in their respective institutions in terms of the Act of 2016. Mr. K. Gogoi, Standing Council, Higher Education, submits that Section 6 within bracket 2 provides for appointment of petitioners as tutors, for provincialization of the services of the petitioners as tutors, subject to fulfillment of the criteria laid down for the other criteria laid down in section in the Act of 2017. Accordingly, considering the limited prayer of petitioners, this petition is disposed of, directing the concerned authorities to consider the case of the petitioners, to consider the provincialization of the services of the petitioners as tutors, of the remaining petition as tutors in their respective institutions in terms of the Act of 2017. So, it is an admitted position that these remaining petitioners do not have the requisite qualification of NET, SLET, and PhD degrees. However, in terms of Section 6 within bracket 2 of the Act of 2017, the case of the petitioners may be considered for provincialization as tutors, subject to fulfillment of all other eligibility criteria prescribed in the Act of 2017. Let such exercise be done and completed within a period of how long?
3 months.
3 months from the date of receipt of the copy of the order of this court. With the opposite observations and directions with petitions.
I,
Yes,
Was appointed in the year 2002 as project officer of Logic and Philosophy.
oh,
Logic and Philosophy. An example from our page 18. Thereafter, madam, yes, proposals was given the comment, and ultimately, madam, that was provincialized in the year 2013. All the teachers, including the head staff, they were provincialized. But
which school is this?
the Gurukuti higher secondary school,
Gurukuti High.
that's the one. But everyone was provincialized except her. She was somehow left out. The result which was shown by the department madam, that is that they do not have the feasibility report.
Where is that page?
Madam. It's 30, madam.
Yes,
It's 30, madam. The open madam. The name of the I think so.
Barul Devi.
Parul Devi, madam.
Hmm.
The remark by written that no feasibility report from Assam Higher Secondary Education Council.
Yes. There are two teachers, isn't it?
Yes, madam.
Not only you, two of you were.
Now, madam, I am Parul Devi.
Hmm.
She has been kept up, madam. And this has also been shown, she has been 52, madam. The remark question, madam.
Page?
52. was second number, number two, and this was the remark, my lord. The above mentioned two number of posts of subject teacher have already been mentioned by high government leaders, so and so date set 25/07/2013. But my lord, the first paragraph, the certificate of the Sri E. Bora and Family Union Center has been utilized for want of utility report to be issued by the Assam Health must not be utilized. This is the reason also.
Yes, then
What's about
22. Yes,
this is a data to the deputy governor, sub-regional officer, forum. So what you see the last time, so number 8, Arun Bedi, this is a letter of season 3, which so much is working here. Just put. And her name was also forwarded along with the other candidates. But some of us, she was on the ground showing that they do not have the ability to.
that feasibility report was given.
And as per the activity signed by the council, they said that they have given the permission. As per the activity done by the department, and they shows that they do not have the criteria. Not do not have the eligibility criteria. The appointed officer. One hand, they are saying that you know, eligibility of report.
Yes. Shari? Of respondent number? Director.
There are 5 numbers.
So you're provincialized as a tutor.
Yes, sir. Now, after having this statement, now I think.
Then
In the estimate, we have shown that, but due to non. I think population of the subject of the associate one had was not popularized at the period of at that time. After that, as per that, 11. Section 4(1), all employees working at that time. So, madam, I am saying that this file is not already utilized. But I want to part of my police, at least.
you want your provincialization from the date your
colleagues are there, madam.
Your colleagues were provincialized.
And as per that section 4(1), madam, the service was provincialized as per the rule. All employees working under at that time, madam, have been provincialized. So due to non-fulfillment of the yes criteria, this criteria is not in the report that has been given by the Assam Management Council. And there are 7 madam of the refugee madam. This is that they can also do it now also madam. And it's that there are 7 madam. There are 7 is 4. There's a different way to state that as the service of the citizenship was provincialized as per the Act of 2017. Therefore, the benefit cannot be granted to her from 2013. As the Act of 2017 came to force from 2017. In case of making a decision to provide benefit from 2013, the service of the teacher will be required to deprovincialize first. But let them do whatever they want. They are saying that first they have to deprovincialize the service. Then only the thing can be considered as per the Act.
You provincialized on your own application
Yes, madam. Without
under the Act
discussing-
of 2017.
Madam.
You requested that. You applied for provincialization under the Act of 2017. Now, 2017 does not give you retrospective, isn't it? They don't give you. Then,
But that's why my lordship, I have shown your lordship is for 22, where my name is already there, madam. In the year 2013.
that
So,
I
yeah,
see.
madam.
But it was not considered because there was no feasibility report.
But madam, then my service was provincialized. Already the feasibility report is required from the council. The council has given the feasibility report. As per their agreement, madam.
You filed a swift petition claiming provincialization. As per para 7 of the counter affidavit, you made an application to the authorities praying for provincialization under the Act of 2017. Accordingly, they've done it. If you're saying that this statement is not correct, have you filed a reply affidavit to this counter affidavit?
No, I understand, madam.
Yes?
But,
Then let him file. He has the right to file a reply. I can't stop you. Yeah, Mr.
yes, madam.
SP Das, then counsel for petitioner, prays for how much time? 3 weeks time to file reply to the counter affidavit filed by the Director of Secondary Education. So, praise allowed, list up to 2 weeks.
All right, madam.
I think 6 to 8.
Why two?
Have some business on the ship. So I pray the ship was timing, the timing. So we will take some time. Yeah, then go back. My language and language.
I think was not issuing of LOC when the petitioner is for which they have not been able to get them on the cognition information. They in particular B-farm and D-farm.
Oh,
Without any affidavit.
without any?
Without any affiliation, without any NOC from the government.
I'll satisfy your motion. So I'm not starting motion. Only that motion.
You have a problem at two?
There is this ban of tax matter. After writing code number 2 matter, single man is code number 15. The tax matter is otherwise it's taken up.
Then we'll fix a different date.
Worship, I pray, worship, I also have some difficulty in this case. Worship.
That's why he's having some problem.
Worship, I am ready to give 500 something. So I will type in worship. Worship, if before 150 worship, if possible worship, worship, I will do worship. Because it will take some time, 3 methods in there. Though my language friend was saying something worship, which is not so easy worship. Because pharmacy council granted the permission worship. And they are also instructed the institution worship and report has been submitted for NOC. But subsequently, Lordship, that report they have resolved by saying that the approval was not given from the higher authority. I will come on this.
Again, those officials who were for inspection. Departmental proceeding is there, penalty has been.
Lordship, I referred from Lordship petitioner said, no
Fine,
idea of
access
that.
with the-
So I understand that.
They-
File an affidavit, Lordship, saying something on that, Lordship.
No, what, lots of me become after some time.
After some time, Lordship, I'll, Lordship,
Okay.
Lordship, after some time, you proceed to Lordship. I pray, Lordship, and wait on it. Order in this, Lordship, I'll stay.
Items 9 to 12.
In this case, Lordship, the main regarding the requisition is that they have challenged 3 clauses of an advertisement. Advertisement is regarding a recruitment of teachers in Portland Territorial Council area. They challenge clause 16, 17 of an advertisement of 28/7/2021. We have already withdrawn that and cancelled that advertisement. Nothing survived, but still the other side is objecting. Was that what is fallen out? During the pendency of the litigation, this is come up. So subsequently, when an advertisement is being made, our rights is to be protected. This was only our right.
What rights? Now the advertisement against which you have filed the writ petition, they have withdrawn the whole advertisement.
Exactly. So during the on activity of the whole case in first also.
Huh? Supposing if you are aggrieved by the new advertisement that is in this, then you can come to court. Okay. You are Mr. K. Wanda. In all the writ petitions,
Also, I agree for item number 9,
10,
then item 9 and 11 also.
what about 10 and 12? Okay, then 9 and 10, 9 and 11, I'm allowing you to withdraw. Mr. K. Mandal, counsel for the petitioner. Praise for withdrawal of this writ petition.
All cases have the same.
With liberty to file afresh. Mr. D. Cycle and Advocate
All may be withdrawn.
Advocate appears on behalf of the respondents. A writ petition is accordingly dismissed on withdrawal with liberty as per the separate order for item 11. Also same. But then other councils are not there. No?
They only put up all the cases.
Are you sure?
So what is happened? They will come to us fully.
What is
They are
it?
leading.
So if you withdraw, they are going to withdraw or not?
Let them go.
Where are they?
They're not coming also. Last occasion also they come.
Because of this, Lordship, we have-
I can't keep the Advocate General standing inside the courtroom waiting for your advocates to come.
the liberty Lordship that may be allowed. So they do not have any interest survive. My folly will be able. But these two are withdrawn.
9 and 11 are
And
withdrawn.
Lordship, liberty to come.
10 and 12.
Highly obliged.
You come with instructions even if they can't appear. Yes. Can I pass the same order? You go and take instructions and come back. I, Chaudhary. Who applies for petition?
Last order, my government has to produce a record. Submitted that they have received the record and they take for time for.
Who was it? You have the records? Oh. Mr. Conwar,
Yes, sir, in that matter, I think the AG has made a submission, I'm told.
yes,
Our grievance was only that they, due to the stay order, the face advertisement has not been issued. Now, since the tax has been cleared, they will issue the face advertisement, that's all.
and if you agree, you can come again. Then you'll withdraw it.
The winter order, your lordship will dispose of it, that was a view of the undertaking given by the.
No, he has withdrawn it. They have withdrawn it. They have withdrawn the advertisement.
By year withdrawn.
Yeah. So in the first case, item 10 and 11, 9 and 11, they have withdrawn with liberty to file afresh. Can I pass the same order?
Yes, sir, since there is no live issues, I'm not.
No, nothing is there.
Nothing is there.
Okay, Mr. Item 12 also, the
But
BD
liberty will be given, but
Conwar, the senior counsel for petitioner, prays for withdrawal of this petition with liberty to file afresh. Mr. D. Saikya, same thing. This petition is accordingly dismissed on withdrawal with liberty as well. How about item 10?
sir, your lordship indicated that in view of the order passed in their case, that's why I have withdrawn.
No, I'm passing separate orders.
Keep them there.
Item 12 is also withdrawn. Item 10 is left. Two. Same order I'm passing. Mr. A. Diwar. Senior counsel, press.
Item 13.
Because the selection of principal of college. And tenure.
Then- Can you have it on 14th, next hearing day, Tuesday? That is the difficult. I'm having too many part-heard matters. Now I'm getting confused, which item, which item. We can give a fixed date, convenient to your senior also, convenient to Mr. Sharma also, and then on that day, let there be no adjournment.
I should do on 14, but he senior will be.
When is he coming back? No, Supreme Court matters, Supreme Court, you don't know, anything may happen. It may be spilled over. How about 28 then? 28.
16 minus.
No, 16, from 14 to 22nd, he's out of station, isn't it? Yeah, till 22nd. Can we make an attempt on 23rd?
I didn't do that.
Third, R.P. Sharma, the senior counsel for the petition. On request made on the appeal of Mr. Ken Javdi, the senior counsel for respond number 4. Respond number 4, list the matter on 23rd of February. Favor. Yeah, it's a fixed item. This is Gogoi's case, item 3. It's not. What are that?
Hearing.
The disciplinary proceeding, only my reply was left out. Otherwise, the very good. The LIC disciplinary proceeding of a development officer. I had made my submissions, my government had also completed this part. Just my reply was released.
Yes. Yes.
But during the course of my arguments, I had tried to demonstrate before your lordship that in the role of a development officer, all that the petitioner could have done is act as an intermediary between the agent and the client. And ultimately, all insurance policies that your lordship is aware, the agent merely takes the proposal, takes the initial payment for the first installment. Ultimately, the policies are approved in the office by the higher ups. So, my role at best can be that of an intermediary. And if your lordship will recall, the charges against me was that, let us say, one Mr. X had made a deposit as first installment for an insurance policy. The LIC, on account of various reasons, declined the policy. So that amount ought to have been refunded to the Mr. X, but it was lying in the account of the LIC. So these amounts were readjusted in the name of fresh insurance policies, proposals. Now, if these get approved, I could have at best induced that we use this money for making fresh proposals. Ultimately, it has to be approved by the higher ups. Now, they have entirely proceeded as a lordship will recall. They have entirely proceeded on the basis that I have admitted. And that admission I cannot take away. That admission is on record. But what is the nature and extent of my admission? I cannot admit to how it was approved because that is not my role at all. I cannot ultimately, your lordship will recall the charges. They are in the name of different agency codes, which means some agents. I have acted through some agents. Now, neither the agents nor the approving authority are proceeded. So, to that extent, there is clearly a violation of Articles 14 and 16. If the charges are accepted into the totality, I cannot be the only person to be singled out. Even if the allegations, as it is on its face value, which my admission is taken into account, from start to finish, it is a sequence of events. And in that sequence of events, I could have played only a very small role. As I have, if you just to refresh, if your lordship will
kindly come back to the duties of the lordship will kindly take up the repetition.
Or Chowdhury, let's take it up on 21st. Today I have, yeah, today I have some.
Fine.
List the matter on 21st.
21st. Yes.
It's a hearing day.
Fine.
That's what. Just check the full day. That's missing. Okay. Just check it. I've seen some of the adjustments here. I don't know what is it. Books is difficult for me to get in there. If not, or call it.
I think 20 of supplementary list. Part of hearing that.
I was on next.
Who's on next?
Then it was
This also will put 21st. Yes.
Right.
Fifteen, 16, 17, and 18. Actually, in all the cases, we have the restriction on aspect of academic festivals.
1 minute. I didn't get that.
We have the restriction for the aspect of only academic for my senior campus, senior brother also. But also in other repetition also, we have not. So I have taken consent from my senior also that I have any other day also.
You've given your consent.
Just there are more matters.
Where is
One matter actually, but there are three other matters. I don't. I think I could be three other matters.
chairman matter we have not done copy loss. We have to construct. My seniors matter we have done copy loss. So also we may take it on after 2 weeks or 10 days to see intermeter will construct.
But Mr. M. Nath, the senior counsel for the petition in WC 4803 of 2016. Also heard Mr. M.P. Sharma, learned senior, learned counsel for the petitioners in, you write the other cases. Huh? So. On request made by Mr. K. Gogoi, learned standing counsel, second higher education. List the matter after.
My senior takes on 14th of March. Change them.
List the matter on 14th of March.
It's convenient. Otherwise, I leave to worship. Or 16th is a tough. Yes, your worship.
16th of March. Mr. A. Khanigal, learned counsel appears on behalf of the NCT. Oh, NCs. Unless they were saying after K. Majumdar.
I think 3.
Which one? Item 3. You are appearing in this matter. Earlier was B. Gogoi. Item 3. This portrait matter. This portrait matter. You want it on? You give a date.
Possible next year. Next.
On request made on behalf of Mr. UK Nair, the senior counsel for the petitioner. List the matter on 23rd.
6, 7, and 8.
I didn't know. Where is the?
Item 6, 7, and 8.
Then I will come at 2. At 2. How about the part 2? Just call out part 2. If just say part 2.
Part 2 hearing list, item 56.
I'll come at 2 now.
Only 10 minutes.
K A.